purpose of the paper today is to look at a wide range of issues that arise in reviewing agreements for purchase of the plans. And my intention is to look at these from different perspectives. We're going to consider these agreements from the purchaser's point of view. We'll look too at the vendor's requirements, and we'll also consider the lender's requirements, which are extremely important in how these documents are drafted. My intention is, or my hope is, that whichever party it is that you're acting for, you'll gain a broader understanding of the agreements from the point of view of all involved. And my hope is that that will help you with negotiating these agreements and understanding perhaps what can be negotiated, what can't, what is the reasoning for the different provisions that are in the documents. And there are quite a range of issues. These agreements, you know, they're complex. They're drafted at a time before they're implemented. They're drafted in one market to identify and need to be effective in a different market. Sometimes they're drafted before laws are introduced that will impact on how the settlement takes place or what goes on in the interim. Think about the myriad of changes that have happened over the last couple of years with the type of information that we're expected to collect on a settlement. They need to accommodate changes in personal circumstances too, for a number of the parties that are involved. And so somehow these agreements need to be robust and cover these factors and still work and still be clear. And that's why they're complex. That's why they're interesting to draft, because of that forward thinking. So we'll examine the agreements within that context and look at some of that detail. And then at the end, there are some underlying regulatory requirements that we'll also consider that will that impact on the agreements. So let's turn first of all to the vendor's position, because it's the vendor generally that generates the specific agreement for sale and purchase, the precedent form of agreement for sale and purchase. And I want to spend a bit of time just in examining that. And maybe first of all even to ask the question about why do these pre-sale agreements actually exist? Why does a vendor need to have a pre-sale agreement in place? Wouldn't it be better that they simply built the thing and or created the subdivision and then sold ultimately? But of course there are a couple of good commercial reasons as to why the vendor might do that. And the first is that irrespective of their funding, they may want to test the market. They may want to see whether their product is something that the market wants to buy, whether they've priced things properly, to give themselves an assurance that their product will sell. But they'll also usually be looking to comply with a lender's requirements. Almost all developers will use a lender, or maybe even a couple of lenders, and these agreements for sale and purchase must comply with the conditions that will be conditions precedent in the loan offer that the vendors have. So the vendor is motivated to make sure that the form of the agreements meet those requirements. And they're also motivated to ensure that in drafting the agreements there are certain risks that are addressed. They don't want the subdivision to be disrupted. They don't want delays or failures on settlement. And it's within this context that I want to examine typical pre-sale agreements from the point of view of the vendor's perspective. We'll look in a bit more detail at the lender's requirements, so we'll skip that first one. We'll do that a little bit later, and then we'll look at disruptions in the subdivision process. There are a couple of tools. Oh, I missed that, sorry. There are a couple of tools that the vendor will want to entrench in making sure that there is no disruption to the process. And the first is that they'll want flexibility. They'll actually want within their agreement as much flexibility as the market will allow. They'll want flexibility in what it is that they're developing. They'll want flexibility on what's on the title and timing and who might be involved, a number of different issues. And we'll look at these in more details. And I guess that degree of flexibility will depend too on where in the process they are. If things are at an early stage, more flexibility might be needed. If there's no resource consent, for example, yet, which often there isn't when these pre-sale agreements are signed, then the degree of flexibility will be quite significant. But perhaps if the resource consent has been obtained, then there might be some more certainty about what particularly is to be developed. So we'll look at each of these points one by one. And the needs here will impact on the extent to which the agreement will be able to be